Hello and welcome to episode 78. As I am relocating with my family over the next few weeks, I'm not going to be able to prepare and produce my classic style of podcast that I've done. So in its place, I'm going to be posting some really fascinating classes that I've given in the past to a group of doctors on various topics of Jewish medical ethics. These classes are a drop longer than my normal episode length, but I think that they're really interesting and you'll enjoy them. In today's episode, we discuss the topic of patient autonomy and medical coercion. Does the patient always have the right to choose what they want, even when they're making a poor medical decision? And what can we do about it if that's the path they choose to take? Join me as we discover the fascinating story of Cassandra C, who the state of Connecticut actually took control of from her mother in order to keep her alive. Enjoy! Okay, so first of all, a very, very big thank you to the Benars, especially given the fact that this was put on them in the last minute. Nonetheless, they opened their house and allowed us to come discuss important medical ethics in their house. It's a tremendous, it's very much appreciated, and thank you very much. So the topic tonight, tonight was another, researching this topic was one of those, it's not logical outcomes, but whenever you read stories in the news, now you can read the more left-wing news, you can read the more right-wing news. Whatever you read always has a bias. That's how newspapers work. When I was researching this story specifically, it just came out extremely strong. Most of my information I got from this story, I read through the Supreme Court documents from the state of Connecticut, what they put out. And the story you get from them, when you read their story, is like just a totally different perspective in terms of which details they share and they mention and they don't mention than you do when you just read the CNN article that I forwarded out, which I didn't realize that I forwarded that article. But you gain a whole new perspective. So just quickly give you the background of the case. Everyone's on the same page what we're talking about.
That's why a lot of doctors don't read anything medical in newspapers or magazines.
Yeah.
They know they get trapped.
It's interesting. I'll quote him later, but the main oncologist that was involved in this, I emailed him a few questions, just trying details I couldn't find out. And the first thing he wrote back to me is that if you're preparing a class on this case, whatever you do, don't read what it says in the media because everyone is totally misconstrued. And he sent me the link, which I'd already seen it. But he sent me the link to the Supreme Court documents because he said this is the only way to get the actual facts. So if you read through it, it happens to be a fascinating story, the sequence of events with this girl. There was a girl named Cassandra. She goes by Cassandra C. Her mother's name is Jackie Fortin. Her name is publicized. And she developed a lump on the left side of her neck when she was 16. She went to a pediatrician, and he didn't take the case. He referred her to someone else. Eventually was referred to an oncologist in children's in Connecticut, in Hartford. And they at first looked at it and thought it'd be cancerous, so they took a basic biopsy of it. And it seemed to be that it was Hodgkin's lymphoma. They needed to be more testing just to know the exact what stage it's at and certain more details because of this. The mother, throughout this process of going to various doctors and the diagnosis process and the treatment process, the mother canceled. She didn't show up to probably around 7 or 8 appointments that she had set. She didn't respond to any phone calls from the doctors, pulled them back. She canceled multiple appointments. She switched doctors without telling the first doctor which doctor she was switching to. Every possible way of avoiding treatment, she basically did. The girl herself, Cassandra, so she's been homeschooled the past 4 years. She hasn't been in contact with her father since she was 3. So she lives with her mom, and she basically just exclusively lives with her mother. And she's not a social butterfly. She's homeschooled. She's pretty, I guess I would say, connected to her mother in all aspects and bends herself to her mother's desires. So her mother really controlled all the conversations with all these doctors. And throughout the process, you'll see the extent of it. There's actually, at one point in time, after she was already in the Department of Children and Families in Connecticut, they had her at the witness stand, and they were asking her questions: do you believe that you have cancer? Yes. So do you believe that chemotherapy will work? Yes. And will you agree to do chemotherapy if we send you home? So Cassandra, under oath on the witness stand, said, yes, I will consent to chemotherapy if you send me home. So they said, fine. So she went home. They started chemotherapy. She did 2 rounds of chemotherapy, and then she ran away in the middle of the night. She disappeared. They couldn't find her. The mother said, I don't know, disappeared. I don't know where she is. She wasn't at home. She didn't help. She didn't call anyone. and she was lost basically for a week. And at the end of that week, she came to her lawyer, and they eventually called and started the whole case again. But this was part of the conclusion of the court, that neither her mother nor her was responsible to make the appropriate, or capable of making the appropriate medical decisions. If you see what's going on here, the whole picture of it, she kind of pushed off treatment for around 3 or 4 months on a very deadly disease that's easily treatable. And the daughter herself lied under oath. In addition, she was willing to take rounds of chemotherapy to get home. She just wasn't willing to take rounds of chemotherapy to heal herself. That was part of the main argument that allowed them to say she was not competent to be a mature minor. What? She was first diagnosed when she was 16. Her birthday, I think, is in September. So she was 17 during Moses. This started last year, like August, and this past April, like 2 months ago, was when she finally was released from the hospital, free of chemo. Interestingly, free of cancer. Interestingly, even now, I didn't see her social media page, but I've read articles that said even now she's still upset about the fact that she's 100% cancer-free right now, and she's still upset about the fact that it forced her to do this, and that the whole story is very strange. The mother the whole time never really accepted the diagnosis. She didn't believe she had cancer. She didn't believe in chemotherapy. The whole story is like a strange story. Either way, the question is tonight, that's the gist of the story, and what happened as a result is they put her under the Department of Children and Families in Connecticut, who basically locked her in a hospital room, forced her to do chemotherapy, which the chemotherapy they have, we'll get more into details later, but it has a 95% success rate, the specific thing they were doing, with an 85% non-recurrence after 5 years, which is heavily successful with minor side effects, which we'll talk about. So the story was pretty crazy, but at the same time, they took her away from her mother, they locked her in a room, and they forced her to do chemotherapy. So the question is tonight, that we're going to be our main source of discussion, is what would the Torah say to do in such a situation? What's the Jewish perspective on this situation? And I think we could really break it down into, I guess, four subcategories. And that is, the most basic question is, how does the Torah view her personal autonomy to choose or not choose to take life-saving measures when the odds and the stats are all clearly there of how helpful it will be to take it and how disastrous it will be if not? The doctors said in the case that it will be just about guaranteed death within the next 2 years if the cancer goes untreated. So the question is, one, personal autonomy. Question number two is, let's say that the answer to that question is that she does not have the autonomy. She is obligated to take care of her life and heal herself. But anyway, she says, I don't care. She says, I'm not going to take care of myself. I'm not going to do it. Do we now have the ability or the right or the obligation to go ahead and coerce her or force her to take this treatment? Right? Even let's say the first question is she allowed to decide that or not? If she's not allowed to decide that, but she decides anyways, because everyone has free choice, she chooses the wrong thing to do, are we allowed to now step in and say, well, you're doing the wrong thing, I'm going to make you do the right thing? That's question number two. Question number three is, she's 17 years old, so is that considered a minor? In Jewish law, if we were approaching this case, how would we treat her, right? 17-year-old is legally a minor in America. How do we take that in Judaism? And question number four is, let's say she is a minor, or the equivalent of another minor in a different case, when there is room for autonomy, which there definitely is a place in Jewish law for autonomy, who makes these choices for a minor? Right? Is it the parent's obligation? Is it the rabbi's obligation? Is it the doctor's choice? Who gets to decide medical decision-making for a minor? If anyone else has any other questions that they want to throw out there in terms of the ethical aspects of the case, the floor is open. That's all. The main four questions that I broke it down to.
Just didn't tell you more questions in Yiddish.
Don't do. I don't know Yiddish, but okay. So let's start from the top. Why do we ever have an obligation to save someone? Where does that come from? Why should I care if someone else wants to kill himself? What does that have to do with me? So there's two mitzvahs in the Torah. There's two verses explicitly in the Torah that refer to saving a person's life. There's one positive commandment and there's one negative commandment. The negative commandment is in Leviticus 19:16. Don't stand by idly as your brother's blood spills. Right? Don't stand by when your brother's blood is spilling. Explicit verse in the Torah to teach everyone. This is not a verse exclusively for doctors. It'll be true for the layman as well. You have an obligation. If someone's choking and you know the Heimlich, you have an obligation to do that for them. The second verse is a verse of Deuteronomy 22:2. This is actually an interesting one. The verse says, "V'hashivosalo," and you shall return it to him. The verse is actually discussing the case of a lost object. When somebody loses an object, there is a positive commandment in the Torah to return that object to him. The Talmud in Sanhedrin learns not only is there an obligation to return someone's lost object, but if you have to return a physical possession of his, for sure you have to return his health to him. And you for sure have to help him restore his health. And the Talmud actually learns out of this verse, from the obligation of finding a lost object, that not only that you actually have a positive mitzvah, you shall return to him, a positive commandment, to help someone sustain their life and heal them, which again is not exclusively for doctors. This positive and negative commandment is true for everyone. Everyone who can save a Jewish life has both a positive and negative commandment to do so. Now, where does the doctor fit into this? So doctor fits in like this. There's a third verse. This verse is in Exodus 19:21. And the verse says that two people are fighting, one of them hurts the other one. The Torah says that the one who hurt the other person has to pay his medical expenses. The Gemara learns from here, Talmud expands from this part. And this relates from the verse says, "V'rapo," and you shall heal. "Yirapeh," you shall heal. So it seems that the word is extra. Why does it say an extra word here? So Talmud learns, from here we learn there's a license, an allowance for doctors to practice medicine and to heal people. Right? There's an additional allowance for doctors to heal people. Now the question is, what exactly is this different than anything else? So the Code of Jewish Law says that there's an obligation, since the Talmud teaches us that there's an allowance for doctors to practice medicine, that now translates into the obligation to save people. Meaning like this: you all here know a lot more ways of saving people's life than I do. I maybe could do a few things to save someone's life. Someone's bleeding to death, I could put a band-aid on him. Right? There's certain basic things that I'm capable of doing. Most of you probably know a lot more ways to save someone's life than I know. So now if we come across a person sitting on the side of the road, and he needs a certain surgery, and you know how to do that, or the doctor knows how to do it, and I don't. So I have no obligation to do it to him, because I shouldn't touch him, because anything I'm going to do to him is just going to damage him more, since I don't know the proper medical care for him. A doctor who has an expanded license to heal, that anything that he knows in the medical field that he can do to help this person, he is now obligated to do for this person. So the two positive and negative commandments that apply to everyone, the doctor really has an expanded version of that. Now the question is, what exactly did the Torah teach us when it tells us the doctor has a license to heal? Okay, why would the doctor not be able to heal? He knows how to help someone's dying. What's the problem with that? And are there any limitations to it? If there's some special allowance, it sounds like the default position was don't heal, and the Torah said, no, don't worry, we are allowing you to heal. So in that allowance, is that allowance all-encompassing, that anything you want to do to heal the person you can? Or is it limited to maybe certain situations? So there's a huge debate amongst the medieval commentators exactly what the Torah meant when it gave this permission, this allowance. One of the less quoted commentators, because it's a little bit of a wild idea, but I think we'll try to develop it a little bit and maybe make more sense of it, is that of the Ibn Ezra. Ibn Ezra lived in the end of the 11th century, just to give you a frame of reference, and lived for around 8 years, so well into the 12th century. So the Ibn Ezra says as follows. It says, you might have thought, or maybe in his mind it's really true, that if God makes you sick, so there's a certain act of providence in that. God made you sick. Why should I intervene and heal you? Maybe I should leave that up to God again to come and heal you. Why are you coming to the doctor? So says Ibn Ezra, no, the verse is teaching you that you're allowed to go ahead and intervene and save this person, or help this person. Says the Ibn Ezra, fascinating thing, however, this is only true by external wounds. You're only allowed to save someone or help heal someone. I just took away all your guys' jobs, right? Only allowed to basically by like a cut, maybe a broken bone if it's called external. Only by an external wound. By an internal wound, there's no such permission in the Torah to try to heal a person. And this is really a radical statement, because if you look in the Talmud, there's plenty of stories of different sages and doctors that healed people with seemingly internal ailments, and there's other actual prescriptions of medicine, which we don't rely on the Talmudic medicines, but that talk about ingesting things for stomach issues and all these different things, which seems to be very, hard to fit into this understanding of the Ibn Ezra. So the question is, really, what does he mean? So there's an idea I saw. I don't know if this is the right answer or not, but there's a much later commentator. This one, his name is Rabbi Yaakov Emden. Yaakov Emden, he died in 1776, so lived around 80 years before that. Rabbi Yaakov Emden said he's not discussing this topic. He's discussing actually is one of the biggest sources on this topic of coercion in medicine. He's discussing coercing someone to take treatment, but we'll ignore that for now. I'll come back to that later. He says a very interesting statement. He says that when you're coercing someone for medicine, you're not allowed to just do what you want. It has to be a medicine that is a known medicine. It's like been experimented on. We know this is a good medicine, and you're 100% confident in the diagnosis as well. It's only for a known diagnosis with a known cure that you can then potentially coerce for medicine. And he calls that, says, for example, an external wound where we know exactly what the problem is and we know how to treat it, that you'd be able to coerce someone for. So I've seen people wanting to suggest, I think this is the most logical idea also, that what the Ibn Ezra is teaching us is that the Torah is only giving us an allowance, he's providing us an allowance to take medicine that we know works and apply it in a situation that we know the issue to heal the person. Meaning when the Ibn Ezra says you can only heal external wounds, not internal wounds, what he means to say is when you know the problem and you know the cure, you're then allowed to go ahead and treat it. That doesn't necessarily mean that it's outside the body or inside of the body. Nowadays, in today's modern world, we know very well the inside of the body and how it works, and we know how our medicines, through trials and stuff, we know very clearly how those work also. So in our world nowadays, it would seem that the doctor would have the obligation, this is why we all can continue to work, we have the obligation to treat people since we know the problem, we can diagnose the problem properly, pathologist like Mike, and we can solve the problem through data that has been tested and we know very well. Now, how does this translate back into obligation? So there's two perspectives here. The patient themselves is no worse than any other person. If I have an obligation, a non-doctor has an obligation to save someone who's dying, for sure that person themselves is no worse than me, and they also have that obligation to save themselves. They really have even more of an obligation, because there's another verse that says, "V'nishmartem me'od nafshech," and we should safeguard your soul very much. So a person has an extra obligation to take care of himself, in addition to the fact that he's no worse than anyone else, and he has to save a life if he can. Now, if we follow through logically, that would include seeking out medicine, and it would include seeking out any medicine that is proven to work, even if, let's say, you don't want to, right? Because you have an obligation to heal yourself. There's a license and allowance to take medicine that includes any known item that will cure you. So therefore, from the aspect of the patient is obligated to go take this medication, this treatment. Now, there's also the perspective of the doctor. The doctor has a patient here. The patient is not being compliant. So now the doctor has a personal obligation. If this doctor knows how to give chemotherapy, I couldn't give that to this patient to save her life. But if there's a doctor that knows how to do that, that now becomes the doctor's obligation to fulfill that for this patient, right? So that's kind of the setup of the question here, and the background information is basically from a perspective of what's the patient's obligation, what's the doctor's obligation. It's interesting if you...
I have a quick question.
Go for it.
So, does the patient have an obligation to listen to the doctor? Because there's many times when a physician says that you need this treatment, and they go, "Oh, I've been doing homeopathic stuff."
So it's interesting. In this case, in one of the videos I saw of her mother's interview, her mother went all over the media gamut, interviewing herself, talking about this problem. They didn't have, in this specific case, any plan at all of an alternative therapy. That wasn't even ever part of the argument. The argument was, we would like to look into an alternative approach. There was no, and this is after she's had this for almost 6 months and being diagnosed with it, and they still hadn't found, they weren't actively actually searching anything. Whether or not you could take an approach of homeopathy is really a class into and of itself, and it depends on what form and what you're doing, and if there's any evidence or any really more societal acceptance of being a real approach in medicine, which normally is based on whether or not the government recognizes it as a valid form of practicing medicine. That's kind of how, in a nutshell, it comes down to. But in this specific case, that wasn't even what they were saying. they were saying that, yeah, we're going to look into it, we're going to find something else to do, but they didn't even come with any other approach of what they're planning to do. This is in contrast to American law. In American law, you don't have, I wrote down the quote from there's a case, McFall versus Shimp, which the court said, quote, common law does not require one to render life-saving assistance. That is a ruling from the Supreme Court, and the other, a ruling from the Supreme Court that regarding the patient's obligation. Now, I'll have to keep in mind, because here she's a minor, so it's different. But in the famous case of Coercing versus the Missouri Department of Health, so the court ruled there that the United States Constitution would grant a competent person a constitutionally protected right to refuse life-saving hydration and nutrition. Right, that was a quote from the Supreme Court of America. So clearly in American law, you have the right to choose basically to starve yourself. I don't know why that is legally different than any other form of suicide, which is illegal. But you are allowed to resist even nutrition and hydration, which is not even chemotherapy. It's a much more basic, essential aspect of life. But in American law, you are allowed to. That's just to point out the contrast here. In Jewish law, you're not allowed to say, I just don't want to eat anymore and kill yourself. You have an obligation. God gave you your body. You're entrusted with taking care of it. You have an obligation to heal yourself, not just to eat and to drink, but also to go do chemotherapy. If this chemotherapy is proven to work and to help you, and you have a life expectancy of less than 2 years, and you'll most probably be completely cured without it, you have now that obligation of the patient to go ahead and do this. So, in our specific case, that would translate into Cassandra seems to definitely have the obligation to go to a doctor, and if she's considered a minor, her mother would have the obligation to. The part of the obligation of feeding your children is also keeping them healthy and making sure that their medical needs are taken care of. We spoke about this last class by vaccination also. That's part of the parent's obligation towards the children. So it would be her obligation to seek the appropriate treatment to deal with her deadly disease. Now the question here is she wasn't doing that. So if she's not doing that, what do we do? So as an introduction, we mentioned this before, but it plays a big role here also, and that is that the definition of a minor in Judaism for all laws across the board is how old? Right? 12 and 13. For a girl, it's 12. For a boy, it's 13. Bar mitzvah, bat mitzvah, that's the becoming of age. Once you are 12 for a girl, 13 for a boy, your business transactions are legal. You can testify, you're considered an adult regarding testimony in court. Whatever action you do, if you damage someone, you're held liable for damages you do. You're considered an adult once you're 13 years for a boy, 12 years for a girl. So, in the simple sense of making medical decisions, you would seem to be also that age once you are 13 for a boy and 12 for a girl, which would mean that in our situation, Cassandra would be considered an adult regarding the Jewish perspective. And whether or not it makes a difference if you're an adult or not, in this particular case, it doesn't really make a difference. Because since you have an obligation to take care of yourself, that obligation is the same for an adult and a child. Even though she's technically an adult, she would still have that same obligation of making sure that she's taken care of. It's interesting in the dialogue between her and the doctor, the main doctor, the head of hematology and oncology and children's in Hartford. His name is Dr. Isikoff. I'm not sure I'm pronouncing that right. And in his conversation with her, she expressed her opinion to him that, this isn't really fair because I'm 17 and a half. If I were just 6 months older, I could just do what I want and you wouldn't be able to tell me anything. And so he responded to her, answering the statement, he responded to her, technically you're right, we would be having a very different discussion if you were 18, but I would question your competency with the decision you're making even if you were 18 the same way. Meaning, which in American law makes a difference because once you turn 18, now you have the autonomy to choose it. But in terms of the right or wrong decision, it doesn't really matter ethically, the right or wrong decision, whether or not you're an adult or a minor. In the Jewish perspective, which is always the basic contrast between the Jewish perspective and the secular perspective, and the specific point is more of a general approach to, I would say, rights versus obligations. The Jewish perspective on really everything, you don't find anywhere in the Torah the concept of a right being mentioned. There's no right to education, there's no right to healthcare, there's no rights in the Torah. But the Torah always discusses the obligation. It's an obligation of parents and of society to ensure that the children are educated. It's not the children's right to be educated, it's the obligation of society to ensure that they are educated. Healthcare is the same way. There's no right to healthcare. There's an obligation on the doctors and on anyone who can heal people and restore their health to do what they can to help the people of the community. As opposed to in America, where the focus is always on the individual's rights, what I'm allowed to do, when you get focused on your own rights, then that whole perspective just basically changes to whatever you personally would like, rather than what there's some other opinion that can be, I guess, objectively ethical or unethical. It changes to what you view as being fair to yourself. So that's where the main point of differentiation. So, just to summarize, Cassandra definitely is making the wrong decision, and she should be taking chemotherapy. Now we come to our question as doctors, as what do we do about that? Am I able to now coerce her to go ahead and take chemotherapy? Or am I saying, okay, you're making the wrong decision, you're not doing the right thing, I can't do anything about it. So the context of most of this discussion in Jewish thought is very interesting. The place where it's written most about is in the context of what we call a pious fool. There's a person who doesn't want to break the Shabbos, or who doesn't want to eat on Yom Kippur, the Day of Atonement. And the doctors are telling him, if you don't do this certain action on Shabbos, or if you don't eat on Yom Kippur, you will die. You need this nutrition, and there's no question that if there's a discrepancy between eating on Yom Kippur or dying, we for sure say you have to live. Living overrides just about everything else in the Torah. So therefore, you would definitely have to live. So if somebody says, I don't want to eat on Yom Kippur, it's too holy to me, I don't want to eat, but tell them you're making the wrong decision, right? That's the question. Now, but let's say he's saying that. So now can we go ahead and can we coerce him to eat, or can we coerce him to break the Shabbos or whatever other, officially forbidden action it would be, but that's supposed to be broken in order to facilitate life? Can we coerce him to do that? So this point has endless amounts of writing on this question. I'll just bring out two scenarios that are very interesting case studies on this topic, one ancient and one recent. There's if you look at a Talmud, so the middle of the page is the Talmud itself, is the Gemara. On the inside of the page is Rashi, or Shlomo Yitzchaki, and on the outside of the page is the commentary of Tosafos, or the Tosafist. Now, Tosafos was composed of many different authors. It wasn't one person. It was compiled over 100 years, more or less, with different authors. One of those authors went by the name of Riva. Riva is an acronym for Rabbi Yitzchak ben, meaning the son of Asher. Now, it's brought down it's documented in different books that Rabbi Yitzchak ben Asher was of very, very weak health. He was approaching Yom Kippur, and the doctor told him, you have to eat or you're going to die. And he said, I would rather die than eat, and so happened. He refused to eat, and he died because of that on Yom Kippur. Now, this was a great sage whose commentary we learn all the time, and a lot of people are bothered by it seemingly clear that the appropriate ethical position is that eating overrides, that saving life overrides fasting on Yom Kippur. So what was he thinking? What was he doing? There's a lot of answers thrown out, but this is a very real question. They didn't treat him in any way of considered like suicide or anything like that, but it's a big question on him, how exactly he was able to do that. A second, more modern case, which is also a very interesting case, is more controversial, but it's still controversial. It's the case of Kurtam versus the state of Israel. Israel has slightly different autonomy policies than America. It's more or less the same. Doesn't follow the Torah law, but it's more European. But the main difference is they also go with autonomy. They have a little more of a reliance on retroactive consent than we do in America. So there's more leeway to do something to the patient, assuming he's going to retroactively consent to it, which in America wouldn't go the same way. So this case Kurtam was a suspected drug dealer, and basically what the state did, or I think the state did, was they forced him to have surgery, and they took out of his stomach 2 bags of heroin. So now the state then, I don't know exactly what these kind of bags, I don't know exactly how it would work, but they took out of his stomach 2 bags of heroin, and the state used this heroin as evidence against him in regards to the drug dealing. Kurtam claimed that I never consented to that surgery, you were never allowed to take that out of me in the first place, and that is not valid evidence in the court of law since it was obtained through illegal means. This case went to the Supreme Court in Israel, and the Supreme Court ruled, again, this ruling is not necessarily based on the Torah, but it's just an interesting case to think about. The Supreme Court ruled that since he would have died otherwise, the reason why he would have died is not because he was in actually grave danger of dying at the time, but had either one of those bags of heroin burst, it would basically immediately kill him. So therefore, it was considered legal to coerce him to have that surgery. Since it was legal to coerce him to have that surgery, it's now considered legal evidence against him in the court of law, and that was how it was answered. This is like an often brought up case even in American literature in regards to patient autonomy in these types of situations, Court versus the State of Israel. But that's what was done in that case. So the question is, what's with our case? Yeah, our case again, do we have the ability to force her? And we can really ask this question in two ways. She has a personal obligation to heal herself. Can we force her to do her obligation? Nothing to do with me. Can I force her, you have this obligation, can I force you to do your obligation? Then there's a second question is, let's say I can't force her to do her obligation, but I have my own personal obligation. I have an obligation to save another person. So if I have an obligation to save someone, that's irrelevant of her obligation to save herself. Even if I can't force her because of that, I might have my own obligation, nothing to do with her at all. Really. Okay, we're all good. So I start with the first one. Can we force her to do her obligation? So the official answer is yes, but practically the official, and when a Torah law rules the land, there are certain abilities that the court system, which is called Sanhedrin, has to enforce certain commandments being observed properly. One of those commandments is safeguarding your life. In this situation, you are allowed to force her to take the life-saving treatment that would allow her to do that. In America, we don't have a Torah law that's running the books here. We're subject to American law, and not only that, but there's an obligation. Within Torah, we hold what's called Dina de Malchusa Dina, which means the law of the land is the law, and we're obligated to follow the law of the land that we live in. We are obligated to follow American law. So therefore, if let's say, we'll get back to that in a second, but we're not necessarily allowed to go force her to do her obligation if that would be against American law. So now in this specific case, obviously it wasn't, because American law itself decided that she was able to. But that's the question. Now the question is, in terms of our obligation, are we, doctors, able to coerce our patients to do it, to break Shabbos, to eat on Yom Kippur, or to take a chemotherapy that's necessary for her? Just to point out exactly the level of therapy we're talking about, I couldn't find online a lot of, in terms of Jewish law, a lot of it depends on the risks involved versus the rate of success. Like there's a certain very practical, statistical importance to the fact. So I couldn't find anywhere in any of the documents what exactly the risks of the chemotherapy were. Everyone was talking about how it has a high percentage of success rate, but it didn't really discuss anywhere the risks of the chemotherapy. So I emailed Dr. Iskov. That was one of the questions I asked him. Most of the questions I asked him, he told me it's a violation of HIPAA, so he can't answer me. But this one he was able to answer, and he said that I'll read to what he wrote. In general, for advanced stage Hodgkin lymphoma, there's an overall survival after 5 years of 95%. And as you have correctly quoted, the 5-year disease-free survival is 85%. From a toxicity standpoint, the regimen of chemotherapy is extraordinarily well tolerated. Acute hematologic toxicity is mild. Patients normally begin to grow their hair back during the last 4 courses. Nausea is minimal to mild and responds to treatment for most. Significant bacterial infection reported on the study the treatment is based on is 0.8%. I am not aware of any literature that has reported a toxic death from the chemo that we use. So the risk involved in this case was extremely minimal, right? It was basically, no? You disagree with that?
It's pretty minimal, but you also have to take into account long term.
What do you mean by that?
Depending, usually with Hodgkin's, there's radiation involved.
Other cancer later.
So other cancer later just from the drugs, sometimes actually for...
In this specific case, they didn't need radiation in this specific case. They didn't have to get to that. But at the same time, it was untreated, was almost guaranteed death in 2 years.
Oh, for
So you're just saying that still, but the fact that she might.
She talks about it, of course she should take it.
No, please.
But, putting a poison into her body. There are some liver stuff later, depending on what the chemo is, heart toxicity later, deafness, depending on, when you give it, she's not a small child, when you give a smaller child chemotherapy, there's a lot of things that can happen. It still it's not death.
Right,
but,
for sure.
but
So it's interesting, there's one source, the earliest source on coercion in medicine is actually a Tosefta in Shkolim, which is a Tanaic source in times of the Mishnah, and it's talking about there you're collecting the every person in all of the Jewish nation gave 1/2 shekel towards the Korban fund, the sacrifices in the temple, and everyone, it was a joint sacrifice from every single person in the whole nation. Everyone gave basically, let's take $50, and through this the millions of people built up enough money to provide sacrifices for the year. People that didn't give this money, everyone had a personal obligation to provide this $50, let's say. Anyone who didn't give this $50, when the Torah courts ruled the land, they would go and they would enforce. Everyone has a tax of $50, and you have to give this tax. And the Bryson, the Tanaic source there says that just like a doctor who can force a person who needs a leg amputation to have his leg amputated if it's going to cause him death, so too we can enforce taking the $50 from the person to provide it for the korban fund. So this is debatable. A lot of people discuss this price, exactly what the context was, exactly what the disease was. The whole context of that is not 100% clear. But definitely if we're talking about death, and for sure by, let's say, amputations, where amputations doesn't have any long-term effect other than you're missing the limb that you're amputated on. I mean, it doesn't have the same similar things, I think, as far as I understand, to am I right? Correct me if I'm wrong. Mm-hmm. Meaning it's normally like an isolated place, and when you cut it off from the body, what I understand, the rest of the body still is intact, more or less. So it could be that's not exactly similar to, but I mean, you're missing a leg, right? You're definitely missing something. There are long-term effects in a practical sense. But
there's many, because most of the people that go through amputations are diabetic, and it just starts with the ankle and it goes below the knee. I mean, things just keep happening, and then they eventually do die anyway. So that could
you're saying that would happen whether or not the leg was amputated? That would be even if the leg was.
Yes, absolutely, because diabetes is a disease of circulation.
Right. So just as you get closer further from the core, it gets weaker and weaker.
So it's very common for that scenario, and everybody hears about that, and so they form opinions. I don't really want to be chopped up and then end up dying, which is truthfully oftentimes the case.
Interesting. Okay, I don't know so much on the topics. Maybe there are more ramifications. That was the example given. So there definitely is room. If you're talking about a life-saving therapy, where you're for sure going to die now, and there's a risk of perhaps getting another problem later, but as for now, for sure, I get you. I don't know the specifics. I don't know exactly what therapy he was using. I couldn't research exactly what the long-term effects of it are, but that's why I asked him. Accordingly, he said it is that it's a specifically light type, that Hodgkin's lymphoma, the specific form they use is pretty light. So for sure, from that perspective, it would be that it's pretty clear that they would have the ability to enforce that. Definitely the default opinion in the Torah is that God entrusted you with your body. You're obligated to take care of that. If you are not taking care of that, the doctor himself has an obligation to save your life, and he also can force you to take care of that. Now that would be the background to approaching any case. Obviously, just as an aside, the way every single case has different variables in different cases, and you need to judge each case differently, but as just kind of a guideline, there's 3 limitations to this rule of coercion. Seemingly, at face value, coercion is fine, since it's life-saving, and assuming that that's 100% true. Right? If there's a difference of opinions amongst doctors, everything we're saying right now falls apart. We're talking about a case like this, where every single doctor that saw it, and she went for 3 opinions, she kept switching doctors, every doctor agreed this is the right therapy that she needs to do. And when everyone agrees to that, then you, for sure, would have to do that in Jewish law. Now, there's 3 limitations to coercing a patient in Jewish law. The first one is stated by Rabbi Moshe Feinstein. And if you read he has a few different responses on this topic. And he mentions a new aspect. And this aspect is the psychological trauma that a person who's forced to do something has as an effect of being forced to do it. And he writes that the effect of the trauma is often just as great. I don't know exactly what disease he was talking about, but it's just as great as the disease itself. And if we're going to go in and we're going to force them to do something, they're going to be fighting us, they're going to be against it, and they're not going to accept the treatment, and they're going to be making it not work properly, it's very possible that the patient will die anyways because they don't want this treatment, in which case you're now actively making the patient die as opposed to letting them passively die on their own from the disease. So Rabbi Feinstein, and he almost across the board will forbid you to do any aspect of coercion without informed consent, not because you need to inform the patient, but just because it's counterproductive to actually force the patient to do it. Now, I asked Dr. Issakoff if that's standard procedure and whether or not they went through how exactly had a psych analysis in the situation and how they figured she would come across with it, and he told me he can't respond because of HIPAA. So I don't know exactly how much they took into account the specific aspects of psychological trauma in her case or not. She's out of the hospital now. She said, I think she is seeing a psychologist from things I've read, and she has experienced some trauma, but it doesn't seem like it's some life-threatening trauma that's going to necessarily be with her long-term, assuming that her cure does last and she's able to continue. So that's limitation number one, which really limits almost all cases of coercion. Like you need consent in order for it to be helpful for the patient. Rabbi Feinstein does write, there's actually a fascinating law in the law of doctors that a patient is actually obligated to see the best doctor treat him available, which means that you really should discover the best doctor and send all of your patients to the best doctor for this thing. The problem with that is if everyone went to one doctor, we would never function. So the rabbis gave basically anyone who's approved by an official board of medicine, which nowadays all doctors are, is a certain level of trust that this person is capable of above that level of the best doctor, what they were looking for. They meant a trained, knowledgeable doctor. However, if there are multiple doctors available, you need to move the patient over to another doctor. So Rabbi Feinstein writes that if you're incapable of convincing a patient who needs a life-saving therapy that you're clearly not the best doctor for this patient, you should try to find them a doctor who will be able to speak with them in a better way and be able to relate to them to convey to them the greatness of life and how they should definitely help save themselves. That's limitation number one. Limitation number two is twofold. One, there's a law on the land, and we're not allowed to be criminals. As Jews, we're obligated to follow the law of the land. If we're living in America, we have to follow American law. If American law states that you're forbidden to coerce a patient into a certain surgery, and you're doing it anyways, and you're held accountable for criminal action, that inherently it justifies you not doing it because we're obligated to keep the land of the law. In addition to that, you're not obligated to lose your practicing license to save a person. Meaning you're now, if you would do this, you would never be able to practice again in America. You would never have any livelihood anymore, and you basically would destroy your professional life. You're not obligated to risk that much to help a patient who's doing the wrong thing. So that's another limitation, which again, most situations in modern day America, if you're dealing with an adult above the age of 18 who chooses to refuse life-saving therapy, in most situations it would be criminal to force them to do anything, and you would lose your license. This would also apply in almost all situations. The third limitation is Rabbi Shlomo Zalman Auerbach writes, he's talking about a case there of a terminally ill patient who was blind and had multiple heart and lung problems. He already had one leg amputated, and the doctor said he needs to amputate the other leg. So he couldn't handle it. He didn't want the pain of another amputation. He didn't want to be a double amputee. He was anyways terminal. He wasn't interested at all. Well, the doctor said we'll extend his life for however much time it was. So they asked Auerbach, can we coerce him? Should we force him? Or how should we approach this situation? And he said that if it's an anyways terminal patient and there's a major surgery with a lot of pain, you cannot coerce him to do it. Now these are the basic three limitations, which in a practical sense will limit autonomy in almost all situations. If we would apply it back to our case, each of these three, so Rabbi Auerbach's reason is for sure doesn't apply, because he was talking about a terminal patient. She would die without this, but with this, she has a full life expectancy. Maybe there would be some difficulties, but as far as I know, there was a full life expectancy afterwards. The second answer, breaking American law or losing a license, obviously is not true. The Supreme Court ruled that they were allowed to, and he didn't lose his license. The third aspect of Rabbi Feinstein is very hard to know exactly how to place it. The psycho trauma of this specific case, I don't know exactly. It would seem to me that I assume they did do testings like this before they approached anything in terms of forcing someone to. I mean, they couldn't do. There's two types. You can either do it through, I think, through your heart or with a regular needle in the vein, intravenous, right? I believe they tried intravenous. What's it called? What's it called? But what?
Peripheral
In
line.
line.
No, so they tried the regular IV. That didn't work because she had weak veins. It was they had to put in
Central line.
a central line. So they had to put in, which is more invasive and more uncomfortable. And I'm assuming that before they did this, they had proper psychological. I don't know exactly what they did. I'm not sure exactly how they hold her down or eventually she agreed. I don't know the practical things of how exactly played out. But I assume they tested for them. If that would be true, then according to Rabbi Feinstein, it would come out totally fine as well. So it would seem that the Torah law would, in this situation, agree. And the truth is that as a final law in the Torah of whether or not you can coerce payment, although the practical endpoint is basically more or less going to be the same as America, because you're bound by American law. So if American law gives you that autonomy, you kind of are stuck with it. In addition, with Rabbi Feinstein and everything else, it's extremely rare that you're able to. Where it'll really practically make a difference is nowadays a lot of doctors, people that I've met before, you can tell me how you find in your practices, are very open to not even really trying to explain to a patient that your life is on line and your life is valuable and you should try to do what you can. It's just kind of, if you want to not do this, fine, go ahead, you don't have to do anything you don't want to do. The only place where I guess Judaism would really, in a practical sense nowadays, differ on that is the doctor will try to take more of an approach of explaining to the patient that they have this great gift of life and there's a tremendous value to it, and trying to not obviously physically coerce them, but to explain to them that this is the ethically appropriate thing to do. And just as one last point on this our specific case, as far as I know, is not talking about a Jewish patient. I don't have Fortin is her mother's name. Doesn't sound very Jewish last name. I don't know. Probably she was. So this would apply for a Jew and for a non-Jew in this specific case. There's even in terms of her personal obligation, a non-Jew is commanded the 7 Noahide laws. One of the Noahide laws is murder, and suicide does fall under it for sure in regards to this. It falls under the category of murder. So not treating a highly treatable disease. You can debate whether that's really technically called suicide or not. It could be suicide is only when you're more active in the process of not. Here it's more of a passive suicide, you're allowing it to kill yourself. But it would seem to me that under the Noahide laws of of not killing yourself, you'd be obligated to issue healing also. And if that's true, so then she would have that obligation for herself, and the doctor, who I think is more probability of being Jewish, Michael Issakoff. Could be. So him for sure would seem to have the obligation to help her save herself. Okay, thank you very much. There's definitely a lot more in terms of the last part of it, but it's like a whole discussion of itself, so I'm going to, but it's very interesting in terms of medical decision making for a minor. But I don't think we have time for that tonight, but any questions anyone wants to know?
In the halakhas of just returning a lost object, if the person that lost the object is not doing anything or interested, is it still an obligation to return the object? Since we're deriving the obligation of the doctors to heal based on that, if you don't have any obligation if the guy is not interested in getting it.
So everyone heard what Salman said? Salman said a great thing. There's a Minchas Chinuch. Minchas Chinuch is, 1700s? Minchas Chinuch writes, the great rabbi, so he writes that if the source of restoring health is returning a lost object, let's say somebody intentionally loses an object. What do you mean? They're driving in their car and they throw out the window their watch. Right? And then you see them, they threw it out the window. That's what's called an intentionally lost object, meaning he relinquished ownership over it. He gave up on it. He doesn't want it anymore, right? So if that's the source of restoring health, maybe we should apply that same logic. And just like if you intentionally lose an object, you don't have to return it to the guy anymore. So too, if someone's intentionally losing their health, you shouldn't be obligated to help them. That argument is made by the Minchas Chinuch and by the Chacham Shlomo. There are two rabbis that hold that opinion, but just about everybody else known, and definitely all of the major codifiers of Jewish law don't agree with that opinion, and especially since there's another prohibition of don't stand by idly, so that you wouldn't help that, meaning each one of them both coexist. So the logic is a good logic, and there are those that say it, but definitely in the practical sense we don't rely on that.
Thank you for listening to the Thinking Jew podcast and for taking the time to study Torah. and deepen your connection to Judaism. If you found value in today's episode, please leave us a rating or review and subscribe to the podcast. If you have any questions, comments, or topic requests for Rabbi Moshe, please email thethinkingjewpodcast@gmail.com or visit thethinkingjew.com.